You have an awesome invention idea that's going to be an amazing product or business, but you realize you can't start making public disclosures, public uses, or offers for sale of the technology before filing a patent application. Otherwise, you would be forfeiting patent rights, or somebody could possibly steal your idea. So you realize you have to go to a patent attorney to help draft and file a patent application first. But how likely is it this patent attorney is actually going to steal your idea? Whether that's creating their own business around the idea, selling the idea to somebody else, or patenting that idea themselves. I'm going to explain why it is extremely unlikely, if not a zero probability, that that's going to happen. But at the same time, some cases where you want to be cautious. So one of the biggest reasons why folks are concerned that patent attorneys might steal their idea comes from a misunderstanding of what patent attorneys do and who they are. So to be a patent attorney, you have to be an attorney, so you have to pass the state bar in at least one state, and you also have to pass what is called the patent bar, which allows you to represent clients before the United States Patent and Trademark Office. And to take this patent bar, you have to have a technology background. The idea here is that patent attorneys need to understand the technology of their clients as well, if not better than them, to be able to represent the clients effectively. They have to draft these detailed invention descriptions that are part of the patent applications. So as far as what patent attorneys actually do, it's going to be planning patent protection, drafting and filing patent applications, which again are these huge detailed invention disclosures of how the invention is made and used. A lot of times it's going to be 20, maybe to 100 pages, including these figures. The application is filed at the USPTO. It waits in line for 1 to 3 years before examination begins. And then the patent attorney is going to help with his examination process, which is good to think about it like a negotiation with the examiner. The examiner is going to do a prior art search to determine whether what is claimed is new and non-obvious, and is going to send out rejections in the form of what is called an office action. So the patent attorney then is going to help you with these rejections and either amend the application or argue against rejections. And there a lot of times there's many rounds of this back and forth. And so the patent attorney knows the law and knows the technology and knows how to make the appropriate arguments. Hopefully you successfully get the examiner to agree that what you have claimed is new and non-obvious. They will allow the case, and then it will issue as a patent. Now, what patent attorneys don't do is they don't make commissions on selling ideas or brokering ideas. That's just not something that patent attorneys do. It's really only going to be in planning patent protection and then working things through the examination process and potentially patent litigation. So patent attorneys aren't brokers. They're not people who deal in patents. Also, as an attorney and as a member of that patent bar, there are a lot of ethics requirements, including not being able to disclose client secrets and not being able to have conflicts of interest. So just inherently in the ethics, it's built in that attorneys are not allowed to steal their clients' ideas. So in the end, patent attorneys make their money off of the patent work itself. They're not doing things like brokering ideas or brokering patent applications or issued patents. That's just really not part of their job. The analogy I like to use is kind of like with the gold rush. Patent attorneys are the folks selling the shovels. They're not the people out there who are the prospectors, who are trying to find claims and who are trying to actually do the mining themselves. They're just the folks who are selling things to the people who are the miners, who are, analogous to inventors and entrepreneurs. Another reason why folks may be concerned about a patent attorney stealing their idea is from a misunderstanding of how startups work or how entrepreneurship works in terms of bringing a product to market. So the first is that it is really difficult and time consuming to create a startup or to even bring a simple invention to market. It is a very difficult, expensive, risky, and time-consuming thing to do. So there's very little value in bare ideas themselves. And the value is in actually executing that idea. And again, that's something that is extremely difficult and time-consuming. But then what about, say, licensing or selling ideas? Even that is really, really difficult. And especially at early stages, there's not a lot of value in just a patent application where there isn't actually a market or a business around that patent application. So, it's not something where there's a lot of money. Patents are not a get-rich-quick scheme where you file a patent and then you sell it, and it doesn't really work that way. And so people who think that it's some sort of get-rich-quick scheme where patent attorneys can patent something and sell an idea, it just doesn't really work that way. So let's go over the 3 main ways that a patent attorney could theoretically steal your idea and why none of these make any sense whatsoever. The first is that they could take your idea and they could actually create a business around that idea or actually sell the product themselves. So we already kind of talked about it. It's really impractical to do that. To be a patent attorney, you spend a lot of time drafting patent applications and working stuff through the examination process. That is the work that you do. You don't have time to have a full-time job as a patent attorney and then steal somebody's idea and bring it to market. Also, there's a lot of risk there too. So even the best ideas, there's absolutely no guarantee that somebody's going to be able to bring that to market. And so people always underestimate the difficulty that it takes to bring products to market and the time that it actually takes. So it really doesn't make any sense that a patent attorney is going to steal an idea. They would much rather make money off of drafting patent applications and doing their basic job as a patent attorney. If anything, they can probably make more money doing that. Also, they risk losing their license with the patent bar and with their state bar as well. So if somebody's idea is stolen, the patent attorney is going to lose their license at the USPTO or their state license, and they're not going to be able to make money the way that they typically make money, that being, again, drafting the patent application and doing your basic patent work. So it doesn't make any sense to put their whole career at risk just to steal an idea and then have to spend a lot of time and a lot of effort and take on a lot of unnecessary risk, even if it's an amazing idea. Next would be the patent attorney potentially selling the idea to somebody else. So again, this kind of comes back to misconceptions about ideas. There's very, very little value in ideas. Again, the value is in actually taking that idea, implementing it, and bring it to market. Ideas, honestly, are kind of a dime a dozen. Where investors get involved and where there's a lot of money is where they have a team of people who can actually implement an idea. So even if a patent attorney had a bunch of ideas and had people that they could bring them to, a lot of times companies aren't going to be interested in that. They're like, we have plenty of ideas. We're good. We don't need your ideas. No matter how great they are, or how much money we could potentially make off of them, we're not going to give you any money for those ideas. We come up with our own ideas all the time. That's effectively worthless to us. So the idea that a patent attorney is going to steal your idea and sell it to somebody else just doesn't make any sense. Now, third, there's the risk that the patent attorney is going to take your idea and they're going to patent it before you do. Okay, so this also comes from a misconception about the patent process. So typically, even if you start with a non-provisional patent application, that waits in line for 1 to 3 years before examination begins. And the examination process is typically months, if not years. So it's not like something where a patent attorney is just going to file a patent application and then quickly get an issued patent to then be able to sell to somebody else. It is a long-term process and not something that is really quick. Also, there's a lot of filing fees involved in the patent application process, and a patent attorney isn't going to want to spend that money. Even if it's a great idea, the time and money involved, it doesn't really make any sense. And so even assuming that the patent attorney gets an issued patent that they had stolen from somebody else, then are they going to be able to sell it? Typically, no. There's not a lot of value in just bare patents where there's not a company associated with it or there's proven value in something. Really, patent assets that are the most valuable, they're related to companies that are startups who have a proven market and have shown that there is value there. So as far as just selling patents or maybe licensing the technology to somebody, that's really, really difficult to do. It's really time consuming. And honestly, it's very much like pennies on the dollar compared to an actual startup or company that has value around patent assets related to a product that they're actually selling or producing. Now, I'm certainly not saying that you shouldn't be cautious when talking to a patent attorney, and here are some of the things that I would suggest looking for. So first is consider where they are practicing. So if they are at a firm or they have a solo practice, their job is typically going to be, again, drafting the patent applications and working them through the examination process. That's how they're making money. Alternatively, there are some patent attorneys who work in-house at companies. Those are not patent attorneys that can represent you, nor should you be telling them your ideas, because they're the folks who are going to be potential competitors. So, obviously don't talk to patent attorneys who are in-house counsel at a company, especially a competitor company. Also, be wary of any folks really, but especially patent attorneys, if they're at some sort of patent brokerage, or they're at a patent search firm, or they do patent searching and analysis. Those are kind of fringe practices, and ones where people, their motivations may not be always in the appropriate places. And there could be concern there. So I think it's very, very unlikely that even those people are really going to steal ideas for the reasons I previously described. But if anybody is going to, it's going to be folks who are working in an environment like that. Also, for any patent attorney that you're working with, make sure you do your background due diligence on them. So one, make sure that they are a registered patent attorney at the USPTO and are licensed to actually represent you. So you can go to the USPTO website, I'll leave a link down below, and make sure that they actually have a registration number, and that they're actually in practice actively. And also make sure there's no complaints against them. I'll leave a link down below as well, where you can determine whether they've had some complaints filed against them for doing shady things to clients. Also, in addition to the United States Patent and Trademark Office, that being associated with their patent bar registration, you can also look at their state bar. So a patent attorney has to be barred in at least one state. Figure out what state or states the attorney is barred in and look them up there. Is their registration in that state? Is it active? Are they in good standing? Have they had any complaints against them? If they have, then they might be shady and might be somebody who could be potentially willing to steal your idea. So when you are finally ready to talk to a patent attorney, my suggestion would be to talk with them openly about the invention and talk about all the details. Don't hold anything back. Otherwise, your consultation is going to be effectively worthless and you're really not going to get a lot of value out of it. If you don't feel 100% confident about telling the patent attorney your idea, find somebody else that you are going to be comfortable with. That is absolutely essential to establishing the right attorney relationship.